So in response to these broad array of challenges, governments have been putting up walls and restrictions on the internet and on the free flow of information and on data. Some of these restrictions have been put in place for legitimate purposes to further privacy, network security, fair commerce. Others are less defensible and are intended to unfairly support preferred commercial interests, to quell domestic political dissent. And sometimes governments pursue these actions which may be well-meaning, but can have serious unintended consequences for the internet, for other parts of the network than those areas that the regulations were initially intended. So to help us understand these complex issues, this suite of intersecting jurisdictional data flow engineering questions, we have a distinguished panel. So I'll first introduce myself. I'll be moderating. My name is Jonah Hill. I work with the National Telecommunications Information Administration, the U.S. Department of Commerce. And my colleague and co-sponsor, Carolina Rossini, will introduce our panelists. We're missing one, but we've got 3 others who are some of the leading experts on these issues, and we'll start a moderated discussion. There'll be an opportunity for everyone to ask questions towards the end. We're going to save some time for that as well. So Carolina.
Thank you, Jonah, and good morning, everybody. I want to reinforce the thank you for all the panelists and all your time, and also to our rapporteur, to our remote moderator, and to the organizers such as Frank, one of our Brazilian hosters here at the room today. But going back to the panelists in this order, I have at my right side Sunil Abraham. Sunil is the executive director of a Bangalore-based research organization, the Center for Internet and Society. He founded Mahiti in '98, a company committed to creating high-impact technology and communication solutions. So at the end of the day, he's one of the great experts there at intellectual property, internet governance, privacy, and more. Vince is coming. Maria Schake, did I say that totally wrong? She's a Dutch politician. She's a member of the Democrat 66 and has been a member of the European Parliament with the Alliance of Liberals and Democrats for Europe party since 2009. She grew up in Leiden and went to high school in a lot of amazing universities here. I have her bio very complete if you want to learn later. It started with like fundamental preschool.
Oh, there it is.
Hi, Vince. Come, please, join us here. Joining us now, no need for much introduction, but Vincent Cerf, one of the founders of Internet, and he's the chief Internet evangelist for Google. We also have with us Larry Strickling, the head of the NTIA agency in the US, coordinating a lot of telco and internet governance discussions for the US. So no further introductions because we are running out of time. The panel is going to work in 3 sections. We're going to first pose general questions for our provocateurs, and then some specific questions. And in the 3rd section, we're going to open for participation and discussion from the audience. You guys can, whoever want to make an intervention, please just make a line by that wall so you have access to the microphone. So I think the first question we have here is, as with all the public questions, governments must weigh trade-offs between competing priorities and objectives. In the case of the internet and global data flows, the trade-off is often between human rights, openness, economic growth, social development on the one hand, and sovereignty and security on the other. In recent years, the scale seems to be tipping towards sovereignty and safety at the expense of openness. What is going on, and what are some steps that we as a global community can take to tip the scales in the other direction? So each panelist is going to have 3 to 4 minutes to speak, and we're going to be controlling the time. Sunil, please. We're going to go in this order.
So I'll start off by answering the second question, which is what is going on? And the answer to that question is that the blocking of free flow of information on the internet, or what is referred to as the fragmentation of the internet, or what some other people call the balkanization of the internet, is the symptom. It is not the disease. The disease is the unsolved jurisdiction problem. The problem of jurisdiction on the internet was identified by scholars in the early 90s. But since then, even though we had had many fora such as the IGF for learning and discussion, there has been very little progress on solving this problem for most of the countries that are online. There is one small exception to this, and that is the Internet and Jurisdiction Project. And thanks to the amazing work by both Bertrand and Paul, we have some progress. But unfortunately, nation states and corporations remain skeptical of this project and are not supporting this project like they should, with commitments and checks in both senses. And therefore, they are not making as much progress as they should be making. In other words, as long as the problem of jurisdiction remains, the balkanization of the internet will continue. There is no way of stopping it. A few countries, similar-minded countries, have managed to solve this problem. That is because they have managed to harmonize both substantive and procedural law across their borders. And therefore they become one larger jurisdiction and can hold other actors to account. And also enforce rule of law and protect the rights of their citizens. The second comment I'd like to make is on this sentence, which is the trade-off between human rights, openness, economic growth, social development on the one hand, and sovereignty and security on the other hand. I don't think that is an accurate description of the trade-off. There are many trade-offs within those categories. I will give you just one example. Within human rights itself, many different human rights are in conflict with one another. The right to privacy conflicts with the right to transparency, for example, or the right to information. But there are optimization solutions today, as Edward Snowden says. Transparency should be directly proportionate to power. And I have provided a corollary, and that is privacy should be inversely proportionate to power. So there are ways in which these conflicting rights can be balanced or optimized, and these are the places where we should invest our energies. Thank you.
Thank you, Sunil. Jonah, back to you.
Well, maybe we can give the other panelists an opportunity to make some opening remarks on that question. Generally, do you find that the question is really one of jurisdiction, or are there other fundamental questions at play? We can go with Maritja.
Thank you. Thank you very much for organizing this important discussion. I think one of the risks is that we think in terms of trade-offs and sort of zero-sum relations too much. I would push back against that. But we do see that what I think most interesting promise of the open internet to foster perhaps more horizontal relations between people and to allow citizens, internet users that live in countries with authoritarian or repressive governments to enjoy the universal human rights such as freedom of expression and access to information with the help of the open internet. On the other side of that promise, we see unfortunately that a lot of states are seeking to enhance their own grip and power through the use of new technologies and also the internet. And I think that the whole question of what is legitimate regulation and what is not is kind of at this intersection, but we have to distinguish between motives and responsibilities that governments have to look at whether they are legitimate or not. And I want to note here too that not only authoritarian or repressive governments have a tendency to use security arguments to restrict freedoms, but unfortunately also open societies, and I think that that's a grave mistake. The conflation of national security and network security, or using national security as a reason to legitimize control over internet and infrastructure, is a big problem, and sometimes actually undermines both national security and network security. So briefly, just to clarify, because the debate on quote-unquote regulating data flows is often too broad, and perhaps this is deliberate, but it's important to distinguish that there could be reasons such as the protection of fundamental rights, which is a different reasoning than protectionist reasons, just to protect domestic economic actors, or, as I mentioned, broad and excessive security measures. And in Europe, we see a tendency to have the Universal Declaration of Human Rights, fundamental rights, being leading in accepting some compromise in economic efficiency towards more respect for rights. And I'll just end there so that we have enough room for discussion. But it would be wrong to frame every regulation as either a protectionist measure or as a balkanization of the web. There are legitimate reasons, and I would say protection of people's fundamental rights also online is a legitimate reason to regulate.
Thank you for using 1 minute less of your time. Strickling, please.
We have a serious timekeeper here. I've made my time limits every time so far this week, so we'll see how we do. I'd like to unpack the question a little bit to provide a little broader framing, because I think when we talk about free flow of information, I think there are two components of it that we need to keep in mind. I think at its most basic, I think what the vision is, what the shared norm is, that any device connected to the internet ought to be able to share information with any other device on the internet. And it needs to be able to do it consistently, and I think in that point I would emphasize it should be without regard to geography, so that if I can communicate with an endpoint when I'm in my office in Washington, D.C., I ought to be able to do it when I'm in Brazil, and so on. I think the other aspect of this that ought to be evaluated then is the economic efficiency. And so sometimes when we talk, because we want the network to be allowed to evolve and operate as efficiently as possible, because that's what leads to a lot of the growth and innovation what we want to continue to see on the internet. But I think as one evaluates the different measures that might be taken with respect to interfering with free flow, I think you need to look at both of those, because it's not clear automatically that a measure taken that might impede economic efficiency necessarily interferes with the first provision about being able to always reach another source at any time, at any place. And I think when one is analyzing responses by whoever in terms of things that change the internet, we ought to look at both of those and evaluate them under both lenses. The other point I'd make is that it's not just governments that can interfere with this. I guess we're going to focus on that here in this session, but people ought to keep in mind that businesses make decisions all the time that can have some of these impacts, and other players in the internet space can do that as well. But so people just need to understand that governments are the ones that I think we're going to focus on today, but it's by no means just limited to governments. And I think when we do talk about the measure governments take, I can't really speak to whether or not the trend line is continuing to increase. There certainly was a bump in the last 2 years. I'm not sure whether that increase in interest in governments taking action in this space is continuing to grow or is somewhat leveled out. I'll leave that to the experts who are monitoring the field more closely than I am to make that judgment. But I think one of the things that certainly emerged in the discussion over the last couple of years is the fact that for the most part, when the motives to inject some of these measures have good motives, the idea of protecting one's citizens or in terms of protecting their privacy, that I think increasingly governments are finding that these measures aren't really going to be particularly effective. That doesn't necessarily speak to the countries that want to use these measures as a way to impede access to content or be able to control what their citizens are seeing. But certainly if we're talking about, is data more secure when it's kept in servers of one country pursuant to data localization law? I think increasingly people are coming to the realization that that's just not the case. And so some of the premises for engaging in applying some of these measures, I think is being undercut as people get more experience with them. I look forward to talking more about the jurisdiction point. I think it's a very, very important one that has been raised, but I'll save that for later.
It's Vince Cerf. Actually, Larry has already made a couple of points that I wanted to make, but just to reiterate, localization does not confer security. Just putting things in a particular place doesn't guarantee that they're any more secure. The internet is a wide open environment. Attacks can come from anywhere, and that, of course, is why there's a great deal of concern about securing the network. The second point I want to make is that the internet was designed in a non-national way. It was deliberate. We were talking about networks and interconnecting networks, and we didn't care where they were, where their parts were. Some networks could be spanning the globe. Some networks might be local. It was irrelevant in the architecture and in the protocols. We thought that a society would arise out of the connectivity of the internet, and I think we've seen that. We find people discover each other based on their common interests, discovering a common website, discovering being on the same mailing list. And the value of discovery of common interests across the globe, I think, has been a powerful element of the internet's utility. Another point about open data flow is that the utility of that open flow is very central to cloud computing. At Google, we have data centers that are scattered around the world, and we take advantage of the fact that they can move data from one data center to another to replicate the data, to assure that it isn't lost even if a whole data center is disabled for some reason. And the importance of being able to assume that we can move the data freely from one place to another to assure this kind of replication is very important. When Larry mentions anything can be connected or can talk to anything else, this is a fundamental design principle in the internet, but I feel compelled to say that just because it's possible for something to talk to something else doesn't mean that you should force everything to accept any communication that arrives. And so we have to consider that the edges of the net can resist the connectivity and say, I don't want to talk to you. That's just as important as making it sure that it's possible to communicate, but you're not forced to do so. I'll stop there to save some time.
Great. Well, thank you very much, everyone. I guess I'll follow up with a question on potential solutions, because I think we're talking a lot about the motivations behind some of these policies, which include a desire for increased privacy, for ease of access for law enforcement, for fostering a domestic indigenous ICT industry. There's a variety of motivations, some of which are, are intended to pursue, what we might say are legitimate ends, others less so. But when we think about the motivations, it's also important to think about how we might be able to actually design solutions to the problems under that are really the foundation of those motivations. So I might turn first to Vint and have him maybe talk a little bit about some of the engineering rather than policy solutions that have been proposed for some of these fundamental problems. Some things like privacy, there are security protocols that can be used to develop a more robust privacy regime. There's things like DNSSEC, BGPSEC, a variety of other technologies that are being proposed that actually diminish the potential need for these kinds of restrictionist policies, or at least the perception that there is a need for it.
Basically already given half of what I would say, which is, thank you for that.
What happens when you get ripe late?
Yeah, this is very helpful. First of all, cryptography has turned out to be a very important part of provision of privacy, and so Google and others are encrypting traffic as it's in transit. We do so using the HTTPS protocols of the World Wide Web, for example. We also do that when we're moving data from one data center to another. It's encrypted for transport. We encrypt the data once it lands at the data center, so that even if the data center is penetrated, it will make it harder for the party who is penetrating it to make anything useful out of the data. This is all in aid of protecting the privacy and confidentiality of the content of the system that we are operating. The DNSSEC, is Domain Name System Security Extensions, is intended to make it less likely that someone could alter the domain name system to cause a party to go to the wrong machine, thinking that they're going to their bank, and they ended up on a website that has screen scraped the appearance of the bank and invites you to put in your username and password, at which point that's captured and the bad guy uses that to empty your account. We've also concluded that usernames and passwords are inadequate tools for protecting users from penetration of their accounts, and so we've introduced two-factor authentication. Without going into details, it involves having something in addition to knowing something. We're big fans of this. We recommend it to everyone. We make it available to the general public if they wish to use that mechanism. So those are a few of the tools that the engineering teams in the Internet Engineering Task Force and at Google in particular have implemented. There's still much more to be done to increase the security of the system. Routing protocols need to be further secured to keep someone from essentially polluting the routing database and causing traffic to go where it's not supposed to. Those things are underway as well. So there's a deep awareness in the standards making community and in the private sector operators that increased security is in everyone's interest.
So, those issues, I think, get to some of the security concerns and the motivations for restricting data flows for security purposes. But there's a variety of other motivations for data localization, for restricted routing, some of which are for content reasons, for law enforcement access. So I'm wondering, maybe others can speak to some other potential solutions for how to get around some of those other tricky issues that may not be a privacy or security matter, but also is a real, gets at the core of sort of the jurisdictional ambiguity on the internet. So I don't know if anyone would like to chime in on that. Maybe Sunil, I know in India there's been tremendous concern about certain types of inflammatory content. So maybe talk a little bit about some of the things that you've seen in India as being helpful, potentially unhelpful, and some of the things that you've been advocating yourself.
On the question of speech regulation, the myth is that somehow the US is the bastion of free speech, and countries like India are much more draconian when it comes to the regulation of speech. This is due to a definitional problem. It depends what you would consider free speech. For many of us in civil society in India, access to knowledge is a key part of free speech. So when you talk of theft of intellectual property or enforcement of intellectual property laws, often maximalistic intellectual property laws in other jurisdictions, then we see that as equally draconian censorship or regulation of speech. When the average Indian wakes up in the morning, they are not so much worried about consuming political speech. They would like to consume knowledge, culture, entertainment, and so on. So most of the jurisdictions on the planet today are equally draconian. It's just the type of speech that they're interested in regulating. And the US in particular, through its leadership of non-multi-stakeholder, secretive, plurilateral trade agreements, is intent on exporting its maximalistic IP regime to other countries. The complication or the nexus between speech and public order is different in different jurisdictions. When the very first movie was screened, I don't know exactly where it was screened, but when it was screened, there was this image of a train rushing towards the screen, and people were in panic and left the movie theater. So therefore, the nexus between speech and disruption of public order is much more dramatic or much more intense when it is in a place where internet penetration is still very nascent or small. And therefore, it is important for our countries to regulate speech in a much more effective fashion. The Indian executive and bureaucracy has had a mixed record when it comes to protecting the right to free speech. And on several occasions, they have disappointed us with their executive orders and their interference with different types of speech on the internet. However, the Indian judiciary has a much better record. Earlier this year, a draconian provision called 66A in our Information Technology Act was struck down as unconstitutional by the Indian Supreme Court. And today, this very same court is hearing two petitions, one that hopes to decriminalize defamation, and another that hopes to constrain restrictions on speech that are made in the name of hate speech. So it is a mixed track record. Things are developing. Civil society continues to petition all wings of government for greater protection of rights, and hopefully we will make progress. Thank you.
So much, Sunil, for that. And since we are in the half an hour mark, we would like to actually open the discussion with the audience. And if you want actually to send me questions to Twitter, since we are in IGF and we are trying to have a lot of participation, please send at IGF 2015 data flow. And please, if anybody from the audience would like to come to the microphone and pose their first question, the microphone is open.
It's been, while we're waiting for someone to come to the microphone, I can't stand the silence. So I just wanted to make an observation about the way the internet applications tend to work. And one of them is that what other people say, what other people show, doesn't just come flying at you in your face. There's a lot of volition involved in getting access to internet content. Someone has to go and search for something. Someone has to go from one web page to another. Someone has to follow hyperlinks to get from one place to the other. So there's volition involved. And the reason I bring this up is that if, for example, in some country it's thought inappropriate for a party to get access to certain kinds of information, it should be recognized that the party had to take an action to get it, as opposed to sitting back and, in a passive way and be suddenly confronted with something. And so if there are jurisdictional issues, they might be located in the place where the volition took place, as opposed to the place where the content was produced. And I don't know whether that helps at all, but it seems to me important to recognize that this doesn't just happen in a passive way. This is an active, interactive medium.
And Ms. Cheka, I know you said you wanted to chime in real quickly too.
Just briefly, because I think what we're seeing is a situation where, on the one hand, governments are losing grip on the control of information and people, and to a large extent that's welcomed if the open internet indeed enables people's fundamental rights. On the other hand, we see companies of all sorts have responsibilities and play a much larger role in assessing what information is legal, what information is appropriate, in a de facto manner. So regardless of the law of the land in which people access that information. And I think that this role shift should be taken into consideration. I agree with Mr. Strickling, who said we focus a lot on the role of governments, but we must also look at the role that companies play. And in that sense, even though encryption by default, end-to-end encryption initiatives by companies are much welcomed, I don't think we can depend on it. We cannot depend on whether a company sees it's in its business interest to do something that also advances people's universal human rights. And at the same time, we've seen that the governments then have, in the national security interest, even sought to weaken encryption, you know, which has probably hurt both national security and network security and the people using it. So it's like a lose-lose-lose situation. But in this mutually dependent situation, I would just like to stress that I think depending on either technological solutions like encryption or the intentions or alignment of business models and the public interest of companies is not enough. I would like to go back to also a legal and principle-based discussion, and this is where the question of enforceability and implementation is key, and it's not easy. But I do foresee that there will be more multi-stakeholder norm setting or beginnings to be made to define where the mutual dependence lies and where the common interest lies. And in that sense, I would like to point out to an idea, for example, that could benefit all that have an interest in both security of the networks and the openness of the networks, which is to declare the core protocols of the internet as a neutral zone, where no companies or governments would interfere in their self-interest, because the collateral damage for all and for the network itself would simply be too large. Just a thought out there to focus on the mutual dependence and to make sure that we have principles and enforceable mechanisms to safeguard the openness and the security of the network.
Anyone else want to respond? I guess we can take the first question from, can you introduce yourself, please?
Good morning, I'm Daniel Doneda, I'm a consultant to Brazilian Ministry of Justice. Brazil is currently considering data protection regulation, which includes some regulation on international data flows. And we understand that lately several considerations regarding transborder data flows are being done basically on the approach of technical issues, commercial issues, but what I would like to ask the panel, is that to which extent are some considerations regarding human rights and rights of data owners being considered. And this is very important, there's a very concrete and pragmatic question, because based on the last rulings by European Court of Justice, it seems to me that the European Court of Justice is positioning itself as a court which will defend human rights in the information society, and the safe harbor, the ruling regarding safe harbor invalidity took into account the fact that not there were commercial barriers, but that the safe harbor principles were not considered adequate when considering the European data protection framework. And it's not a new argument, this one. Since the year 2000, several people, the DPAs, several governments in the European Union consider the safe harbor principles are weak and principles that would not be aligned with the framework of data protection regulation in the European Union. So when the trial came, on the judgment by European Court of Justice came, for several people in Europe and all over the world, the result was viewed as a natural consequence of principles that were not perfectly drafted. My question is, in which extent, to which extent, by technical, by commercial level, the worry about data rights, data owners' right, will be taken into account into new treaties, into new instruments, and in new techniques of international data borders flow.
Danilo, and just a logistical information, Twitter is actually not working. So if you guys want to make questions, do come to the microphone. Thank you.
So yeah, I thought I'll shift the microphone to a place which is more friendly to the people who like to come up. I'm Parminder from IT for Change, Bangalore, in India. The question is that I think there are this of what flows on the internet we need, and I take the inspiration from the last speaker who said we need to develop new norms, step back and think from the public interest, what exactly are we dealing with? There are different kind of things which flow on the net in terms of the social description of them. I think data as an issue of personal privacy protection and also as an economic resource is different from information/knowledge, which has a common tinge to it historically, that information is a right. Right to information is law in many countries in various forms, and right to access to knowledge is also a kind of a human right. And third is content as intellectual property content. Now, there are three different kind of things. So what looks good like free flow of information, which obviously looks good as a human right, is not the same thing as free flow of data, because data is largely a economic resource. So would you probably start thinking of data, information, knowledge, and content, IP protected content, and some different kind of things? I know there is an overlap because information is as data on Google servers. There is an overlap, but there is a separation, and the separation, when you face complexity, then you probably start differentiating, and that could be a way to approach the subject. Thank you.
Good morning. I'm Bertrand Lachapelle, the director of the Internet and Jurisdiction project that Sunil has kindly mentioned. Just wanted to contribute to continue what he said regarding the fact that as long as the jurisdictional issue is not being addressed, the fragmentation or the dangers of fragmentation will persist. We're in a situation where there is a distinction basically between the situations where there can be harmonization on substance and the situations where there is no harmonization on substance. On cybercrime convention, for instance, or even mutual legal assistance treaties can be improved because there is a goal to have dual incrimination. Something that is illegal in one country is illegal in the other one. On all the speech issues that we're talking about, this is not going to be possible, and it probably shouldn't be possible because there's no convergence. So we are limited to a situation where we have to do with what can be called procedural harmonization, which is some of the things that we're doing. But the point I want to highlight is that because there is insufficiently speedy progress in that regard, every single uncoordinated action by the different governments and also private actors and others is creating a sort of jurisdictional arms race, which for those who are familiar with game theory is a very typical prisoner's dilemma situation, where everybody is making a decision that looks perfectly coherent in the short term for their own interest, but the cumulative effect of all those decisions is making actually the problem harder to solve. And that's one of the key tension. And finally, to Marichia's comment on the core protocols and the public core of the internet, I think is one of the things flowing in the Netherlands. In the Internet and Jurisdiction project, there is one norm of sorts that has emerged in the discussions on domain seizures, for instance, which is that the DNS layer is a neutral layer that is essential for the global interoperability of the network, and that any action at that level has a global impact. It's not something where you can filter partially, it's on-off switch. And therefore, any request for domain seizures or action at the domain name level should be justified by a harm that is actually at the global level, either to the infrastructure itself, phishing, malware, botnets, and all their abuses, or when the entirety of the activity of the site under the domain is dedicated to something that is globally sufficiently accepted as unacceptable. So I just wanted to contribute that and make a bit of advertisement for the workshop we have tomorrow at 11 on those topics.
Did anyone want to respond to any of the three questions and comments from the audience?
Yeah, I'll pick up on and extend some of the implications of Bertrand's remarks. So as we get into these questions of respecting the laws of other jurisdictions and the conflicts that we run into, again, I do think there's two sets of issues we have to talk about in that regard. One is when it's clear that, say, a company in country X is dealing with the private information, the personal information of a citizen of country Y. Today we have issues in terms of how do we actually operationalize those protections. And I do think that's worthy of a lot of discussion. And I think there are solutions that could be found for that. But it I think starts with being able to identify whose law applies in that situation. But I think there's already a strong trend toward recognizing that it's the law, the jurisdiction of the person whose information it is that probably ought to prevail. And then the question is, how do you provide a mechanism by which the company in country X, even if it wants to store the information in country X, affords that information the rights and obligations of the laws of country Y. To me, that may be a coding problem. It's not clear to me that that is a fundamentally impossible problem to solve. The much more difficult problem is when country Y, in determining the protections that are should be extended to its citizen, attempts to basically inject its law into the laws of country X and say, well, country X, in your country, you have to recognize, you know, like most recently, the French case with the right to be forgotten. Those are much more difficult, and I don't know that we have a process today to figure out how to resolve that type of issue. But there you really have it. It's beyond just protecting that information of that citizen. It's now become to projecting the laws of one country into the legal system and rights and responsibilities in that country. Much more difficult issue, and I don't see a quick solution to that type of situation. But I think we have to keep the two of them separate, because it may well be possible to solve the first one if we can get the bright minds to figure out how to do that. And for the second one, it's something we need to keep talking about.
He's the lawyer and I'm the engineer, and so I'm sitting here thinking, okay, you must think that it's a trivial matter to encode the access controls and laws and restrictions of 193 countries into the data that we store at Google, for example. I think this is harder than you made it sound. But I have a question.
That's a problem.
Yeah, I know, we can do anything. Well, there's some element of truth to the fact that you can do almost anything if you can figure out how to write the program to do it. I wanted to ask a question, though, about the uniqueness of the situation we find ourselves in right now, where information flows around on the net and there are concerns about where it is and who has access to it. We have other global communication systems that have been with us for a while, the telegraph since 1845, the telephone since 1876, and the postal services probably even longer than that. And that involved the movement of information around the world. And so the question I have is whether any of those global communication systems posed similar problems, and did we have any solutions for them? It may be that there are no good answers, but I thought it would be worth asking.
Great. Did you have another question, or did anyone else? Oh, real quickly.
Thank you. Sorry, but a lot of questions have been asked. I just wanted to clarify that in the EU there is a clear distinction between how personal data and non-personal data should be treated, and I think that's important, and it's another distinction that's often lost in the public debate, where, you know, open data, anonymous data, non-personal data generated as a byproduct by machines and sensors should all be processed, transferred, aggregated in the most open way. But there are some restrictions for personal data, and I just want to point out that there's already jurisdiction that regulates this. For example, the GATT treaty at the WTO, the Trade in Services, allows countries to make an exception in the flows of data for the sake of protecting people's privacy. So a lot is new, but a lot is also not new. That's what I wanted to point out. There are already agreements and jurisdictions and treaties and other legal frameworks that can be built on to ensure that data can flow, but people's rights are protected. And I wanted to point out that this notion of extraterritoriality is already happening de facto on a daily basis, and at the same time, companies are already adhering to laws of the land on a daily basis. So just an example, when people sign up for any popular social media that probably, you know, numbers of us are using, they agree to the terms of service and to some extent place themselves in the jurisdiction of, for example, the United States if this is an American-based social media company. And we've seen this concretely with a Dutch citizen who had his direct messages, so private messages on Twitter subpoenaed as part of an investigation by the American Department of Justice, and there was nothing that the Dutch government could do to stop the seizing of that data. So de facto American law then sort of reached into you know, the rights of this Dutch citizen. Vice versa, when a company like Google or a social media company wants to operate in a country like Turkey, where the constitution forbids the insulting of the creator of the Turkish state, Ataturk, they have to adhere to it. Otherwise, there's simply no establishing of the company in Turkey. And so the weighing of these principles and interests by companies, by governments, is already happening on a daily basis. So I just think we should not have a discussion as if we still have a blank piece of paper on which we can start drafting laws that would ideally regulate all this. We have to do with an evolving climate of jurisdictions and agreements and deliberations that both companies and states make, and that have real consequences for internet users and sometimes also for the open internet itself.
There. I just wanted to make one other vocabulary point. I hear the word company being used a lot. I assume it's sort of a substitute for private sector entity. But I did want to mention that there are more entities in the internet than just private sector companies. There are all kinds of other entities, government entities, universities, not-for-profits, NGOs. And so I hope that our discussion isn't so narrowly focused that we leave out the fact that there are all these other entities who participate in the internet, who generate and consume information, for example.
Since we have just 10 minutes, Sunil, if you can just talk in 1 minute so we go back to the audience for questions.
I had several things to say, but 1 minute. Just to build on what Bertrand was saying, even when there is overlap of substantive law, and I wasn't advocating for total harmonization of substantive law. I've said before that this lack of harmonization is both a bug and a solution. The existing mechanisms are completely broken. The MLAT process takes 2 years. There's hardly anybody who has been convicted in India using the MLAT process, and the problem is asymmetric. India has the problem, but the US does not have the problem, and the problem is getting worse because countries that receive MLAT requests don't process them with adequate speed. All sorts of lies are being introduced into MLAT requests. So even if the terrorist wasn't planning an attack on US soil, the Indian law enforcement officer will put that in because he knows that the US government will take that request much more seriously if that lie is present in the MLAT request.
And introduce yourself.
Okay. Hi, my name is Burcu Kut and I work for Public Citizen. My question is about trade agreements. So what is the role of trade agreements in this debate? Because the 21st century, so-called 21st century trade agreements include a provision on cross-border data transfers, direct trade obligation on cross-border data transfers, like the TPP text, which was released last week, includes a provision in the e-commerce chapter. And so all these priorities for countries, like the protection of personal information, privacy, or other issues, they become a trade exception. They have to satisfy the exception language in those trade agreements. So I'm quite curious to hear about the trade agreements, because there are rules existing now for the cross-border data transfers or direct free flow of information, whatever you call.
Take another question and then we come back to the panelists.
Hi, I'm Fernando from Youth IGF program. I would like to raise an argument regarding the role of social media platforms. I think we don't have adequate an adequate system to protect the users. I mean, social media platforms have already been refused to appeal several requests from governments because they don't have legitimate interest. And I think we should look on this argument, because the intermediary sometimes and in a daily basis is the only proxy, is the only thing between the user that should be protected and law enforcement. This is.
Did you want to start on TPP?
I was going to respond on the trade issue. I think the opportunity to utilize trade agreements to set some of these norms is an important opportunity, but it's not a totally problem-free opportunity. But I do think if you look at the outcomes in the TPP text that's now been released, you know, Article 14 has some very important protections that relate to the issues we're talking about today. I mean, they do require that no country can require a company to locate computing facilities in that country's territory as a condition for conducting business in that territory, so that gets right to the data localization issue. There's a more general obligation to allow cross-border transfer of information by electronic means. There's a general provision to protect personal information for users of electronic commerce. So, so it is an opportunity to set some of these norms. The reason it's not problem-free, and many people have identified this, is the fact that these are, you know, negotiations that countries view as quite proprietary, and as a result, they're not conducted in an open and transparent manner. I don't know how we solve that problem because of the nature of negotiations. It's like if you take a typical negotiation, if I'm going into my car dealer and trying to negotiate a price of a car, you know, it's not going to help me if the car dealer knows exactly what my limits are and how high I'm willing to go. There's no real negotiation that takes place at that point. So, so you have these questions of how do you trade off the perceived need of the negotiators for the ability to have maximum room and maximum negotiating leverage against the fact that these are really important issues, and in the context if these issues were being discussed in a ICANN or a multi-stakeholder environment, they would be open and transparent. And I'm not quite sure how we resolve that tension, but it doesn't take away from the fact that the trade agreements are a way to set these policies among a subset of countries which help establish norms that could hopefully then expand to the rest of the world.
Anyone else want to discuss the trade agreement angle?
Sure.
Go
Given
ahead.
the fact that I'm responsible for trade in my political group, I also want to point out that there's quite a bit of difference between the Trans-Pacific Partnership and the considerations on the European side when negotiating with the United States. There have been suggestions that data protection and other related topics could be dealt with in TTIP, and I think it is very clear for both the EU and the US that that is not going to happen. So that issues like safe harbor or the question about rebuilding trust or ensuring there's sufficient democratic and judiciary oversight over intelligence services are not topics that can be dealt with in a trade agreement. Now, of course, there will be questions of how to deal with e-commerce questions, or now a hot topic, the issue of net neutrality, where the US has laws, the EU has laws, and it has an impact on the digital economy. But fundamental law cannot be made or changed by a trade agreement. And I think that that is something that the EU across the political spectrum agrees on.
So it's Vince Cerf again. It strikes me that we should keep in mind that all the various threats to security, safety, and privacy are global in scope. There's no place to hide. anyone in one part of the world could launch an attack against anyone else. And so if we are really going to come to grips with our concerns, we are going to have to find common ground, because we will need to cooperate in order to respond to these problems. And it is not a question of drawing lines in jurisdiction, it's a question of coming to common agreements. And without that, I think that we will always find this to be a very, very complex space, and only the bad guys will win.
Thank you, Vince. And we just have 2-3 minutes left. One more question from the audience, and then we are closing the panel. Thank you, everybody.
Hi, hello, my name is Marilia. I'm also with the youth program. Referring to the question of the roles of the companies, what should be the role of governments in regulating big companies that acquire other companies because of the data they hold? And so is antitrust an element of privacy?
Would anybody like to answer on the big platform data competition question?
Well, I guess I represent a big company, but I'd like to point out to you that the problems that you are concerned about are not purely a consequence of big companies. These problems occur across the entire spectrum of entities that are on the internet. And so the concern is not just about big companies, but it's about everyone who might have access to or might generate information that needs to be kept private.
And just to push back a little bit on the comment that Vincent just made, I think it wouldn't be wrong to say that evil is a function of size, and the bigger you are, the more harmful you can be if you want to be. And when in the US, for example, you decide to regulate restaurants, a single instance of a gourmet restaurant is subject to less regulation than a national fast food chain. So therefore, it is not unreasonable to expect that regulation be targeted at larger actors. Thank you.
Just to make it clear, under U.S. antitrust law, these issues would be dealt with based on the economic impacts of the combination. So depending on what data is involved, it may or may not be a relevant issue for the antitrust authorities. And then, at least in the United States, certainly I think more resources get applied to investigations and reviews of larger companies, but that's not set out in the law as a special category requiring special review or consideration.
Thank you, Strickling. And I'm happy to tweet later. The FTC is having a lot of discussions on that and have some documents coming out on big platform competition if anybody's interested on that. But now I would like to pass to my friend Jonah from NTIA to close the panel.
All right, well, thank you everyone for coming. And on behalf of NTIA and Public Knowledge, appreciate and thank all our panelists.